The Department of Justice is using technology right now that did not exist 2 years ago to find compliance violations among gun owners. And if you are a senior who legally owns firearms, there is a very real chance you are already in their system. That is not a guess. That is what happens when you combine a newly empowered ATF enforcement division, a modernized federal firearms database, and a Department of Justice that has been quietly building automated cross-referencing tools that connect your gun purchase records, your trust documents, your estate filings, and your transfer history against every registered owner profile on file. That system is running right now. It is finding gaps. And the people it is flagging more than anyone else are seniors who own firearms with significant collections, people who bought legally, stored legally, and never imagined they were doing anything wrong. I am going to walk you through exactly what the DOJ and ATF are looking for, the 4 specific situations that are triggering automatic flags on senior gun owners, and the 5 steps you need to take before April 15th to protect yourself. But I need to tell you something first that most people do not understand about how this works, and it changes everything about how seriously you should take the next 20 minutes. Here is what changed. For decades, federal firearms enforcement operated with limited coordination between agencies. The ATF had records, local law enforcement had records, estate courts had records, gun trusts had records, but none of those systems talked to each other in any meaningful, automated way. Compliance gaps went undetected for years. Seniors who had been collecting firearms for 30 or 40 years, people who bought every single one legally, who stored them responsibly, who never had a single incident, were making perfectly normal estate and transfer decisions without anyone telling them those decisions had strict federal compliance requirements attached to them. They transferred a rifle to a son without going through the proper dealer process. They inherited a suppressor from a deceased spouse without understanding what the National Firearms Act required of them. They put their firearms into a living trust without proper ATF documentation. They let a registration lapse on a regulated item after a death in the family. Every single one of those situations can trigger a specific federal compliance obligation. And for years, almost nobody got caught because the systems simply were not connected enough to check. That era is over. Starting in 2022 and accelerating sharply through 2024 and 2025, the Department of Justice received a significant expansion in both funding and mandate for firearms enforcement. The ATF rebuilt its data infrastructure from the ground up. Gun trust filings now feed into federal databases. Estate and probate records are being cross-referenced against registered owner histories. Dealer transfer logs are being matched against inheritance records. The system is not looking for criminals. It is looking for paperwork gaps, ordinary people who made ordinary decisions about their legally owned firearms, without understanding that those decisions came with strict federal reporting and transfer requirements. And when the system finds a gap, it does not wait for someone to report a crime. It generates a compliance flag automatically. By the time a letter from the DOJ or ATF arrives at your door, the analysis is already done. They are not asking whether there is a problem. They are telling you they already found one. Now let me walk you through the 4 specific triggering situations, because there is a genuinely high probability that at least one of them applies to you or someone you love. The first and most common trigger is the informal transfer of a firearm to a family member, a son, daughter, grandchild, or sibling, without going through a federally licensed dealer and completing the required background check process. This has become extraordinarily common among seniors, and the motivations behind it could not be more understandable. You have owned a hunting rifle for 40 years. You want your grandson to have it. You hand it to him at Thanksgiving. Or maybe you are getting older and you simply want to make sure your collection goes to the right people in your family, while you are still alive to pass it on with intention, rather than leaving it to be sorted out in an estate. Those instincts are completely natural. But here is what most people are never clearly told. Under federal law, transferring a firearm to another person, even a family member, even for no money, even as a gift, generally requires that the transfer go through a federally licensed firearms dealer who runs a background check through the National Instant Criminal Background Check System. There are narrow exceptions for certain transfers between immediate family members in some states, but those exceptions vary dramatically by state law, do not apply in many jurisdictions, and do not apply at all to certain categories of regulated firearms. If the transfer does not go through the proper dealer process where required, both the person giving the firearm and the person receiving it can face federal liability, and the DOJ's current data matching infrastructure is identifying these informal transfers by cross-referencing estate records, probate filings, and social media activity against registered transfer histories. If a firearm shows up in a new location through an estate inventory, a separate purchase record, or any number of other data points without a corresponding dealer transfer record, the system flags it. The consequences range from civil penalties to criminal referral, depending on the specific firearm involved and the circumstances of the transfer. The second triggering situation catches more senior gun owners off guard than almost anything else, and it involves what happens to National Firearms Act regulated items, suppressors, short-barreled rifles, short-barreled shotguns, and certain other regulated items when the registered owner dies or becomes incapacitated. Millions of seniors legally own NFA items. They paid the tax stamp, they went through the registration process, they did everything right at the time of purchase. But very few of them receive clear guidance on what the law requires when those items need to change hands, even within a family, even after the owner's death. Here is the reality that most people are never told clearly. An NFA item cannot simply pass to an heir the way a regular firearm or a piece of furniture does. The transfer of any NFA item, even at death, even to a spouse, must go through the ATF's transfer and registration process. That means filing the appropriate forms, paying the applicable transfer tax in most cases, and waiting for ATF approval before the item legally changes possession. If a surviving spouse continues to possess a suppressor that was registered solely to the deceased husband without going through the proper ATF transfer process, that spouse is technically in illegal possession of an NFA item under federal law. That is not a technicality that the DOJ is inclined to overlook in the current enforcement environment. And the ATF's modernized data systems are now actively comparing registered NFA ownership records against estate filings and death records to identify situations where a registered owner has died and no corresponding transfer application was filed. The reason this catches so many seniors off guard is that the original purchase process, which was handled correctly, gave no obvious indication that the death or incapacitation of the owner would require a completely separate federal process to maintain legal possession within the family. People assume that if they did everything right on the front end, the item is simply theirs to pass on like any other piece of property. That assumption, however reasonable it feels, is not how the National Firearms Act works. And the gap between that assumption and the actual legal requirement is exactly what the DOJ's enforcement systems are now designed to find. The third triggering situation involves firearms that were placed into gun trusts, which was actually the recommended strategy for NFA items for many years, but where the trust documentation is outdated, incomplete, or no longer compliant with current ATF regulations. The gun trust strategy became enormously popular among firearms owners in the 2000s and early 2010s precisely because it offered a straightforward way to manage NFA items and transfer them to family members without some of the complications of individual ownership. Attorneys marketed these trusts widely. Range dealers had brochures about them. They were a completely legitimate and widely used planning tool. But here is the problem that millions of senior gun owners are now sitting with. In 2016, the ATF implemented Rule 41F, which significantly changed the requirements for gun trusts and the people listed within them as what are called responsible persons. Under the updated rules, every responsible person listed in a gun trust, every trustee, every co-trustee must submit to a background check and provide fingerprints and photographs when a new NFA item is added to the trust. Many trusts that were properly established before 2016 have never been updated to reflect these new requirements. Many responsible persons listed in older trusts have never gone through the updated background check process. And many seniors who set up these trusts years ago have since added family members as trustees, changed their estate plans, or experienced deaths within the trust structure without updating the trust documentation accordingly. The ATF's enforcement posture in 2026 treats an outdated gun trust with unverified responsible persons the same way it treats any other compliance gap, as a problem that needs to be resolved. And their data systems are sophisticated enough to flag trusts that were established before Rule 41F, where no updated documentation was subsequently filed. If your gun trust has not been reviewed and updated by a qualified firearms law attorney in the last several years, you may be sitting on a compliance issue that you have no idea exists, and neither the trust paperwork nor the original purchase receipt will protect you when the flag gets generated. The fourth triggering situation is the one that is perhaps most emotionally difficult, because it typically affects people who were dealing with grief at the time the problem was created. When a parent, grandparent, or spouse passes away and leaves behind a firearms collection, the immediate priority for the surviving family is everything except compliance paperwork. The funeral, the estate, the emotional weight of the loss. Firearms sitting in a safe or on a rack in the deceased's home are often simply absorbed into the household without any formal documentation of the transfer, the provenance, or the compliance history of individual items. In many cases, nobody thinks to ask whether any of those firearms are NFA-regulated items requiring a formal ATF transfer. Nobody thinks to verify that all of the serial numbers are properly traceable. Nobody thinks to check whether any of the items were registered in a way that requires specific handling. They are just guns that belong to dad or grandpa, and now they belong to the family. That is a completely human response to an overwhelming situation. But from a federal compliance standpoint, it creates exactly the kind of undocumented possession situation that the DOJ's enforcement systems are now built to identify. The ATF's modernized records infrastructure is actively cross-referencing estate and probate filings against registered firearm ownership histories. When a registered owner dies and the estate records show a firearms collection, but no corresponding transfer documentation was filed, the system notes the gap. If any of those items are NFA regulated, the gap becomes an urgent compliance issue, not a passive notation. And if an item later surfaces in a sale, in a home inspection, through any number of pathways, without a clear documented chain of legal transfer, the current possessor can face serious federal liability, even though they inherited it in complete good faith and had no idea they were holding anything that required formal documentation to be in their possession legally. I know the question that is forming in your mind right now: how could the DOJ possibly track all of this? How could they know you handed a rifle to your son at Christmas 3 years ago? How could they know your late husband's suppressor has been sitting in the safe since he passed? How could they know that the gun trust your attorney set up in 2012 has never been updated? The answer is what makes 2026 fundamentally different from every year that came before it. The ATF's rebuilt E-Trace system now has data sharing agreements with state-level probate courts, estate administrators, and county recorder offices in the majority of states. When an estate is filed that includes personal property, which in most states includes firearms, that information enters a federal database and is compared against registered ownership histories. Federally licensed dealers are required to maintain detailed records of every transfer they process, and those records are now being aggregated and matched against ownership databases at a scale that was never technologically feasible before. Gun trust filings go through the ATF directly, which means the agency has a complete record of every trust-held NFA item and can monitor that record for compliance gaps in ways that were simply not possible with older infrastructure. Beyond the ATF's own systems, the DOJ's expanded enforcement posture means that local and state law enforcement findings now feed into federal databases with much greater regularity and speed than before. A firearm that comes to the attention of local law enforcement for any reason, even a completely non-criminal reason, now generates a federal records check that will surface any ownership or transfer discrepancies associated with that item. And unlike the old system, where those discrepancies might sit in a file for months or years before anyone reviewed them, the current automated infrastructure flags them immediately and routes them to the appropriate enforcement office for follow-up. The system does not take days off. It does not have a backlog the way the old manual review process did. It processes millions of records simultaneously, and it is specifically calibrated to find the kinds of gaps I have described: the informal family transfer, the undocumented NFA inheritance, the outdated trust, the unresolved estate. These are not rare edge cases. They describe the situation of millions of senior gun owners across the country right now, which is why the 5 steps I am about to give you are not optional if you want to protect yourself. Step 1 is to conduct a complete documented inventory of every firearm you own or that you believe you have inherited or received. Write down the make, model, caliber, and serial number of every single item. This sounds basic, but an enormous number of seniors who have been collecting for decades have never actually done a formal written inventory of what they own. Some of those items may be NFA regulated: suppressors, short-barreled rifles, items with certain modifications, and you may not even know it. Some of those items may have been received through informal transfers years ago that were perfectly common at the time but do not meet current federal requirements. You cannot address a compliance issue you have not identified. The inventory is the starting point for everything else. Do it in writing, date it, keep it somewhere secure alongside your other important documents. Step 2 is to gather every piece of documentation you have related to the purchase, registration, and transfer history of your firearms going back as far as you have records. That means original dealer receipts and Form 4,473 copies were available, any ATF approval letters for NFA items, your tax stamp certificates, gun trust documents if applicable, and any correspondence you have had with the ATF or a dealer regarding transfers. Then compare that documentation against your physical inventory. Are there items in your possession that you cannot find purchase or transfer documentation for? Are there NFA items in your collection that you cannot find an ATF approval letter for? Are there items that came to you through an estate or informal gift that have no paper trail at all? You are not solving the problem at this stage. You are identifying exactly where your documentation gaps are so that you can address them with professional help. Step 3 is to take what you found in steps 1 and 2 to a qualified attorney who specializes specifically in federal firearms law. This is not a job for a general estate attorney. It is not a job for the attorney who drafted your will. Federal firearms law is a specialized area with its own regulatory framework, its own compliance procedures, and its own penalty structure. You need someone who practices in this space specifically. The National Shooting Sports Foundation and several state-level firearms law organizations maintain referral resources for qualified firearms attorneys. When you call, ask directly, do you handle ATF compliance issues and NFA transfer matters for individual gun owners? If the answer is yes, and they can point to specific experience in this area, you have found the right person. A qualified firearms attorney can tell you exactly what your exposure is, what voluntary disclosure options exist, and how to bring your documentation into compliance in the most protective way possible before the DOJ's enforcement systems generate a formal notice. Step 4 is to verify what the federal government actually has on file for you. For NFA items, you can submit a written request to the ATF's National Firearms Registration and Transfer Record to confirm what items are registered in your name. This is an underused resource. Many seniors who believe they have complete records discover through this process that a registration they thought existed is not reflected in the federal database, or that an item they received through an estate is not showing a transfer record in their name. Knowing what the government sees is the only way to know with certainty whether your personal records match the official record. A qualified firearms attorney can assist you with this process and help you interpret what the results mean for your compliance posture. Do not guess at what the federal record shows. Verify it directly. Step 5 is the most time-sensitive. If you have received any correspondence from the ATF, the DOJ, or any federal law enforcement agency regarding your firearms, any letter, any notice, any inquiry, any request for information, and you have not responded to it, address it immediately. Do not handle it yourself. Do not call the number on the letter without legal representation in place. Bring it directly to a qualified firearms attorney who can assess what stage of the enforcement process it represents and advise you on the appropriate response. Federal firearms compliance notices do not go away if you ignore them. Like the tax notices described in the IRS context, they escalate. An initial inquiry becomes a formal notice of violation. A formal notice of violation becomes a referral to a U.S. attorney, and a referral to a U.S. attorney, and a referral to a U.S. attorney is a situation that is exponentially more difficult and expensive to resolve than the original compliance gap would have been if addressed proactively. Every day matters. Every deadline in those letters is real. And I have to warn you about something just as dangerous as the compliance issues themselves. Because every time there is high-profile federal enforcement activity affecting seniors, the scam operators are running their own operation within days. People will call you claiming to be ATF agents demanding immediate action. Emails will arrive with official-looking government seals telling you to click a link to resolve a firearms compliance issue. Companies will send mailers promising to make your federal firearms problems disappear for a large upfront cash fee. The real ATF and the real DOJ initiate contact through United States Postal Service mail. They do not call demanding immediate payment or threatening arrest over the phone. They do not accept gift cards, wire transfers, or cryptocurrency as payment for anything. They do not send emails asking for your personal information or serial numbers. If anyone contacts you and creates urgency around immediate action outside of the formal mail process, it is a scam. Hang up the phone, delete the message, and if you are uncertain, contact a real firearms attorney directly through a referral source you find yourself rather than through any contact information provided by the person who reached out to you. Here is the bottom line. The DOJ and the ATF have more data, more technology, and more enforcement capacity in 2026 than at any point in the history of federal firearms regulation. Senior gun owners are being flagged at higher rates than any other demographic for undocumented transfers, outdated trust documentation, unresolved NFA inheritances, and informal family transfers that did not follow the required federal process. The window to come forward voluntarily, work with a qualified attorney, and address these gaps proactively is open right now, but it narrows significantly as enforcement activity intensifies through the spring and into the summer. The steps are clear. Conduct your inventory, gather your documentation, consult a qualified firearms attorney, verify your federal records, respond to any outstanding notices before the deadlines pass. You did not ask for this situation. Most seniors who are sitting on these compliance gaps made perfectly reasonable decisions about firearms they legally owned, without anyone clearly explaining that those decisions came with strict federal requirements attached. Understanding that does not change what needs to happen next. What changes your outcome is action-informed, timely, specific action taken before the window closes. If this gave you clarity, share it with any senior gun owner you know. That one share could protect someone from a federal compliance nightmare that will cost them far more than it needed to. Subscribe because these updates keep coming throughout 2026. Drop your questions in the comments. Your situation could become the next video. I will see you in the next one.